our attorney misstated that the documents were in fact in the exact order that they were found. I think you can see from the timing of these filings that once we realized that was incorrect, we corrected it with the court as quick as we could.
And so the question is, do you have any information about how the documents that were seized from Mar-a-Lago were misordered?
Let me start by saying I think there's also another filing on this that we did later as well. So between those two filings, what I can tell you is when a search warrant is executed at a location and there are documents in boxes, the search warrant can be executed in a manner where you just take out the documents that you're looking for, or you take the box with the documents that surround that. Both ways are proper. In this particular case, obviously the search warrant happened before I was special counsel, and the special master litigation occurred, or began certainly before I was special counsel. In that litigation, my recollection is that President Trump's attorneys took the position that the government should not have even taken all the documents in the boxes and just taken the classified documents, such that if things were done the way they proposed, there would not be other documents in the boxes. It would just be those. As I think we set forth in our filings, when this issue got raised initially in court, our attorney misstated that the documents were in fact in the exact order that they were found. I think you can see from the timing of these filings that once we realized that was incorrect, we corrected it with the court as quick as we could. And then at that point, when President Trump's attorneys were now alleging that this was an important issue, we looked into in more detail exactly why it was not possible to keep the documents in the exact order. And I would just say everything I say today I'm deriving just from the filings we did on this. But my recollection from those filings is that one of the central issues about keeping the documents in the same order is that President Trump kept these incredibly highly classified documents in boxes with all different sorts of things of all different sorts of shapes and sizes. Clothing, memorabilia, newspaper clippings, things of that nature. And so while agents, I think, sought or wanted to keep the documents in order as best they could, I think once they saw the order of these boxes, clearly that was going to be an impossible thing to do. And so we set out our views about that in these filings. And again, I'm speaking only from these filings.
What's the upshot of the documents being taken out of order?
My view is there is no upshot in the sense of these documents were staff members referred to these documents as the quote beautiful mind boxes, meaning they were and this wasn't just one staff member, it was multiple staff members, and they referred to the fact that Donald Trump, these were his boxes. They were exclusively his belongings in them. He had curated them and what was in them. And so in our view, that was not a live issue in the litigation. Once the defense raised it and said, oh, now that you can't say what order they're in, we think that's a big issue, we responded. But I think ultimately in the litigation, given President Trump stated that he believed these were all these were his documents. And so the litigation in this case, in my view, was not going to turn on the location of documents in the boxes, given his position was all of this is mine.
Do you know if he was intending to save those materials for his presidential library?
You mean the classified documents?
The items in the boxes, all of them.
Well, if he if his defense were that he was intending to take classified documents that he had no authority to take, and he did it intentionally because he wanted to start a presidential library and keep those documents in the locations that we talked about today, that's a crime.
No, but my question was all the items in the boxes, the shirts and the other mementos, were they being saved for a presidential library? To the extent you were able to develop that in the course of your investigation?
You know, I mean, there were newspaper clippings in there. There were, I think, you know, different sorts of things that wouldn't to me seem like the sort of things that would be in a presidential library. To be honest, I've never been to a presidential library, so, but if I were starting one, I don't think that's the sort of things I would put in it.
Okay, but you didn't develop any evidence during the course of your investigation that the materials were intended to be saved for a presidential library?
I don't recall that, and I also want to be careful of not getting outside the parameters of these filings, because I don't think we addressed that issue in the filings we're talking about.
Okay. And during the times relevant that we're discussing, Mar-a-Lago was protected by the Secret Service, is that correct?
That's correct.
So to the extent an adversary wanted to come in and steal some of these classified documents, they would have had to go through the Secret Service to get them, right?
Well, as we alleged in paragraph 13 of the indictment, the Secret Service provided protection services to Trump and his family after he left office, including at Mar-a-Lago, but it was not responsible for the protection of boxes or their contents, and the indictment states that Trump did not inform the Secret Service he was storing boxes of classified documents at Mar-a-Lago, meaning they didn't know that they were protecting classified documents.
Right. But if Joe Q. Citizen had classified documents from their time serving in government and they brought it home to their basement, and some foreign adversary was aware of that, it would be much easier for a foreign adversary to break into the Joe Q. Public's basement and take those classified documents. If the foreign adversary wanted to go and get those documents out of Mar-a-Lago, it would have been a lot more difficult. I mean, a person can't just walk into Mar-a-Lago and try to abscond with these materials, right?
I would very much like to answer that question, but I cannot answer that question due to the final report.
Okay. Was there an effort by your office, did you consider seeking the removal of Judge Cannon?
Again, I don't think that's in any public filing, and so I cannot address that given the injunction.
Whether, you know, the internal office discussions involve consideration of removing Judge Cannon? I mean, that's not something you can talk about?
I don't think I can talk about things today, again, consistent with our discussion this morning. If it's not in a public filing, I haven't seen the final report in almost a year. I'm not comfortable discussing issues like that solely because of that issue.
Okay.
I'm trying to be as consistent as I can about that.
Okay. The book by the Washington Post reporters that we were referencing earlier reported that you considered, and by you I mean your office, your collectively, the collective you, considered petitioning the removal of Judge Cannon, but the Solicitor General's office recommended against it because and if you had gone to the Attorney General, that would have had to been reported to publicly reported to Congress. Is that something you have a recollection of?
Mr. Kessler, sorry, I just, on this point, I just want to make sure that we're in agreement that the Department of Justice has taken an expansive interpretation of Judge Cannon's order in its application to Mr. Smith, and that he's not permitted to disclose non-public information that may be contained in Volume 2 of the Special Counsel's report. And I know you cited this book, but the email that we both received from the Department of Justice this morning said that this prohibition does not apply to information that has been made publicly available through authorized means. And so if something was leaked to some reporters who wrote a book about it, I would not consider that to be made publicly available through authorized means.
Okay. You got a page? Noted, and I'll just to give more context to what I asked, it's on page 349 of the book. It states, the final straw for Smith came when Cannon dismissed the documents case, citing as a basis Thomas's concurring opinion, which carried zero legal weight, making the choice a striking departure from judicial standards. Solicitor General Elizabeth, how do you say her? Is it Prelager?
Prelagar, I think.
Prelager? Okay, excuse me. Ultimately approved the appeal of Cannon's ruling, but the former Garland law clerk rejected Smith's plan to seek to have Cannon recused, saying he didn't have enough evidence to try to remove her. Smith could have asked Garland to reconsider his trusted counselor's position, but he did not. If Garland turned him down, it would have to have been reported to Congress. And so I guess the question in light of your counsel's observation is, if you asked the Attorney General for something and he turned you down, wasn't your understanding that it had to be reported to Congress?
So putting aside this whole
Yes.
situation, I believe it states something to that effect in the special counsel regulations.
Okay, and was that something you were concerned with? That you wouldn't want something like that reported to Congress?
That was not a concern of mine.
Okay. I believe earlier you indicated you did not have any communications with White House officials. I think that Martin already asked you about whether you spoke with President Biden. You said no. Did you have communications with any White House staff?
I did not.
Okay. Did anyone in your office?
My office interacted with staff in the White House in the following ways. There was one instance where, that I recall, where we sought to interview a career National Security Council staffer, and to make arrangements to do that interview, we had to do it through the White House. With respect to the classification of the documents that we were using in the classified documents case, there were some of those documents the National Security Council had equities in, and as a result, we needed a contact point to speak to, I believe it was to speak to a career person who could be our contact point for that classification review. And so there was interaction between my staff and people, I believe, from the White House counsel's office. I would add that all of my understanding and my direction was that any interactions would be pursuant and consistent to the White House contacts policy.
Okay.
And I think also in the beginning of my time as special counsel, there was this litigation I referenced previously about executive privilege. And we noticed both the current White House and though I don't know that we had to, we noticed also President Trump on that in terms of whether they would waive executive privilege or not. I think in that instance, I'm not sure of this, but I think in that instance, we requested the DAG's office to ask the White House about that, and so we didn't have direct contact. But I wasn't involved in those contacts, so I'm not sure.
Okay. So nobody in your office had communications with White House Chief of Staff Jeff Zients?
Not that I recall.
And nobody had communications with the counsel's office in terms of your strategies for prosecuting these cases?
No.